Welcome students. Today we will talk about winding up of company. This lesson pertains to the course Company Law in the 5th semester of the 3-year BCom degree program offered by Dr. B.R. Ambedkar Open University. In this lesson, we will specifically know the meaning of winding up, the difference between winding up and dissolution, what are the different modes of winding up, and what is the procedure for winding up under the Companies Act 2013. So, with this we will get into the lesson. What is winding up? Corporate failures may happen. When a corporate failure happens, it may be because of the financial mismanagement, it may be because the company has done something which is not consistent with its objectives, or the company has fulfilled its objective, or the company is unable to pay off its debts and the company is not allowed to assume further debts. There may be different reasons where the company may have to be dissolved, may have to be wound up. So, winding up is a process of putting an end to the life of a company. It is a proceeding by means of which a company is dissolved, and in the course of such dissolution, its assets are collected, its debts are paid off out of the assets of the company. If any surplus is left, it is distributed among the members in accordance with their rights. So, winding up is the entire process where a company will sell off all its assets. It will realize the sale proceeds from these assets, and it will distribute the amount so collected among its shareholders. Okay, this process is called the process of winding up. Winding up and dissolution are two different things altogether. What is the difference between winding up and dissolution? The nature of winding up is that winding up is the first stage of closure, and it involves the realizing of assets and paying of liabilities and distributing surplus if any, while dissolution is the final stage wherein the existence of the company is withdrawn by law. Winding up is a voluntary process, while dissolution is a compulsory process. So, the procedure for winding up is carried on by the liquidator, who is appointed either by the company or by the court, while the dissolution orders can be issued only by the court. Winding up can be by the company or by the court, while dissolution can only be by the order of a court. Then the liquidator represents the company in the process of winding up of a company, while the liquidator cannot represent the company in the process of dissolution. The creditors can prove their debts in the process of winding up, while in the process of dissolution the creditors cannot prove their debts. Any person can proceed against the company which is being wound up, but in the case of dissolution, no proceedings can be enforced against the company that is being dissolved. These are the points of distinction between dissolution and winding up. But why does winding up happen? What are the reasons for winding up of a company? When the object for which the company is established has been accomplished, the company is wound up. Suppose for example, there is a construction company. The construction company has been formed to construct a dam. After the dam has been constructed, the objective of the company is accomplished. Therefore, it does not have any business to continue. In that case, the company can be wound up. Where the company is unable to carry on its operations or the main object, the company can be wound up. When is a company unable to carry on its main object? When the object is frustrated, when the subject matter of the object does not exist, then the company will be wound up because it is not able to carry on its objective. When the company disposes of its business or the undertaking to another company or individual, when the company sells off its business, the company selling of the business has to be wound up, will be wound up. When the company is unable to pay its creditors in full, it will be wound up because it will not be allowed to assume further debts. In that case also, the company will be wound up. So, these are the different reasons why a company is wound up. Then, what are the different modes of winding up of a company? Section 270 of the Companies Act 2013 provides two modes of winding up. Either the winding up is known as compulsory winding up by the tribunal or voluntary winding up. Compulsory winding up by the tribunal or voluntary winding up by the company members itself. These are the two modes in which winding up is done. Then, when the members, we have talked about compulsory winding up and voluntary winding up. In this voluntary winding up, again there are different modes. Either the members voluntarily winding up, that is internally the company members, the shareholders, they want to wind up the company, or creditors voluntarily winding up, that is outsiders, they wind up the company. So, when the company is being wound up compulsorily by the tribunal, winding up by a special resolution under section 271A. Now, under section 271A, the company, if it has to be wound up, then it has to pass a special resolution, and in this special resolution, the company has to initiate the process of winding up. It has to give a statement that it intends to wind up its operations, and this has to be passed by a special resolution of the shareholders, of the members of the company. Then the tribunal must ensure that it is not opposed to the public or the company interest. Okay, the winding up is not opposed to the interest of the public or the company itself. Now, winding up due to companies acts against the interest of the sovereignty and integrity of India. Now, if the central or the state government makes a petition to the tribunal that the company has done an act which is against the sovereignty or integrity of the nation, then the company will be compulsorily wound up by the tribunal, where such an act is reported to be done by the company against the interest of the nation. Then winding up by the tribunal can be done when the company's affairs are conducted in a fraudulent or unlawful manner under section 271C, where the company's affairs are conducted in a fraudulent or unlawful manner, the registrar of companies makes an application to the tribunal for the company to be wound up. Winding up under compulsorily by the tribunal is also done when the company makes a default in filing with the registrar its financial statements or annual returns for immediately preceding 5 consecutive years under section 271D. So, under section 271D, where the company has made a default, every company is required to file its annual statements, financial statements with the registrar of companies. Where a company has failed to file the annual statements and such a failure occurs continuously for 5 consecutive years, then the company will be compulsorily wound up by the tribunal. Then the company will also be wound up when it is felt that it is just and equitable for the company to wind up under section 271E of the Companies Act. Now, in this situation, the tribunal has very large discretionary power to safeguard the interest of the minority and the weaker group of members. Such a winding up can be done on just and equitable grounds, or the tribunal will pass this order when there is no other remedy available to the petitioner. Where the petitioner has got some other remedy, then winding up is not the option which is available for the tribunal. Now, what do you mean by just and equitable grounds? What are just and equitable grounds? Just and equitable grounds are minority oppression or deadlock in management. Minority oppression. So, where there is a small minority of shareholders and because of their minority they are not able to protect their own interests and the majority of the shareholders are undertaking actions detrimental to the interest of the minority, then the minority interest has to be protected. To protect the minority interest, the tribunal may deem this to be a just and equitable ground. When there is deadlock in management, where the company directors, they are not in a position to carry on the business due to their internal differences. The case law here is NJ Tobacco Limited. NJ Tobacco Limited had directors where the state of affairs was such that the directors were not even there on talking terms. In that situation, the tribunal ordered for the company to be wound up on just and equitable grounds. Then, when there is a loss of substratum, that is, loss of substratum means when the subject matter itself is absent, then it is said to be just and equitable grounds. The case law here is Dunlop India Limited. Now, Dunlop India Limited, it was carrying on its business, but the business was in continual losses. Losses to the extent of 2,300 crores were there on the shoulders of the company, and the company has disposed of the assets detrimental to the interest of the shareholders, and the business of the company was not being carried on profitably. So, therefore, it was decided that the company has to be wound up on just and equitable grounds. These are the different processes of compulsory winding up. Then coming to voluntary winding up, that is out of your own free will. The members will voluntarily wind up the company in the following cases. Case 1, where the period fixed by the articles for the duration of the company has expired. The articles of association may have stated that the company would be in existence for the next 20 years. When the term of 20 years expires, then the company automatically has to be wound up. Or another situation where the company is voluntarily wound up is where the company has any cause whatever passed a special resolution to wind up voluntarily, where the company itself has passed a special resolution to wind up its affairs voluntarily, then the company will be voluntarily wound up. Then we were mentioning that there are two types of voluntary winding up: members voluntary winding up and creditors voluntarily winding up. What is the difference between these two types of winding ups? The declaration of insolvency is the first point of difference, where the members, they declare themselves to be insolvent, where insolvency has been filed, then voluntarily they may wind up the affairs of the company. But in the case of creditors, the declaration of solvency is not required. In the case of creditors, compulsorily winding up. Then the approval of the liquidator. In the case of members voluntarily winding up, the appointment of liquidator is approved by the members only. But in the case of creditors voluntarily winding up, it must be approved both by the members and also by the creditors. Then the control of the winding up process will be with the members in the case of members voluntarily winding up, but it will be there with the creditors in the case of creditors voluntarily winding up. Then the petition for winding up of the company, it has to be as per by who has to give the petition for winding up of the company. Section 272 of the Companies Act 2013 provides the entities that are eligible to file the petition. The entities that are eligible are petition by the company itself, petition by any creditor or creditors, petition by any contributory or contributories, petition by all or any of the prior parties, whether together or separately. Petition for winding up by the company. Petition by the registrar. Now, where there is a statutory meeting, every company by law is required to hold a statutory meeting within 6 months of its incorporation. Where a company does not hold such a statutory meeting, the registrar may file for winding up of the company, may file a petition for winding up of the company. Or when a company does not commence its business within a year of its incorporation, the registrar may give a petition for the company to be wound up. Where the minimum number of members is not maintained, that is, the members fall below the statutory limits. Statutory limits are 7 in the case of a public company, 2 in the case of a private company. When the statutory limit is not achieved, is not maintained, then the company will be voluntarily wound up under a petition by the registrar. When the company is unable to pay its debts, then the registrar of companies will file a petition for winding up, or when just and equitable grounds are found for the company to be wound up, the registrar will give a petition. The central government also may give a petition for winding up of the company where it is found that the company's objective is not lawful. That is, there is an unlawful purpose if the company is allowed to continue, or when the central government suspects any fraud to be done in the company, or there are any fraudulent means that are adopted by the company, the central government may file a petition for winding up. Then under the Companies Act 2013 and Insolvency and Bankruptcy Code 2016, a declaration to the Registrar of Companies stating that the company will pay its dues and liquidation is not to defraud any person has to be filed with the registrar. Okay, declaration has to be given that the company will pay its dues and liquidation is not to defraud the general public. Within 4 weeks of such declaration, a special resolution has to be passed for approval or proposal of voluntary liquidation and appointment of liquidator. Within 5 days of such approval, public announcement in newspapers and websites of the company has to be made for inviting the claims of the shareholders. Within 7 days of such approval, intimation should be given to the Registrar of Companies and the Company Law Board. Submission of preliminary report containing capital structure, estimates of assets and liabilities, proposed plan of action within 45 days to a corporate person. These are the procedures for winding up under the new regulations 2013. Then after the petition for winding up has been filed, verification of claims has to be done within 30 days and preparation of the list of stakeholders within 45 days from the last date of claim receipt of claims. Verification of claims within 30 days and preparation of the list of stakeholders within 45 days from the last date of receipt of claims is required. Then for receipt of money due to a corporate person, bank account needs to be opened in the name of the corporate person having words involuntary liquidation after its name. That is, upon liquidation, if any money is due to a corporate person means an artificial person, another company. So here you do not have any natural person to be paid. Then who should be paid in the case of a corporate person? In such a situation, a separate bank account has to be opened in the name of such a corporate person to whom money is due. And when the account is being opened, the last words in the head of the account should be involuntary liquidation, quote, involuntary liquidation, unquote, after its name. Then the sale of assets and recovery of money due and the uncalled capital is realized. So in the procedure under the new regulations, the assets have to be sold off. Now usually winding up will be done when the assets of the companies are not able to realize or not able to pay off the liabilities in full. In that situation, the company cannot continue to assume further debts, because for every asset there should be an ability to pay off the liability. For every liability that has been assumed, the company's assets should be able to pay off that liability. So where the company's assets are unable to pay off the liabilities, winding up procedure will be undertaken by the company. In that situation, the assets have to be sold off, and if the company has any money that it has to receive from any outsiders, then steps have to be initiated to claim such a money. Steps have to be initiated to realize such money from the outside credit, from the outside debtors of the company. So, where the company has some claims that it has to receive, procedure to receive those claims has to be undertaken, and then uncalled capital. So, as I was explaining, upon liquidation, the shareholders will be asked to pay any calls that are remaining. For example, if the company has got a share capital to the face value of rupees 10 and it has till now called for rupees 7, the uncalled capital is rupees 3 per share. So, the company has to make calls to receive that uncalled capital. Calls means that it has to issue a intimation to its shareholders to pay the uncalled capital. But the company is limited by guarantee, then the members who have undertaken to pay the guarantee amount should be contacted and such a guarantee amount has to be realized. So, uncalled capital and any money due has to be received by the company. Then the proceeds from realization have to be distributed within 6 months from receipt of amount to the stakeholders. So, company will have upon liquidation certain stakeholders whose interest has to be protected. The process of liquidation will take a fairly long period of time. So, after the assets have been realized and when the corporate person account has been opened and money due to that corporate person has to be deposited in his account, and the proceeds from realization means sale of assets, any proceeds they have to be distributed among the shareholders within a period of 6 months from the receipt of amount. To the stakeholders, the amount has to be distributed. Then the final report by the liquidator has to be submitted to the corporate person, ROC, the board, and application to NCLT. So, the liquidator is appointed and the liquidator has to submit his final report of the entire process of liquidation, the process of winding up. What was the assets realized? What were the liabilities that were paid off? What was the amount that was paid to the corporate person? And such a report has to be filed, has to be sent to the corporate person, to the Register of Companies, to the board, and application to the NCLT. The order of NCLT regarding dissolution to be submitted within 14 days of the receipt of order. So, from the NCLT, the order of dissolution will be received, and such an order of dissolution has to be submitted within 14 days of the receipt of the order. So, in this lesson, we have seen what is winding up. We have seen the difference between compulsory winding up and voluntary winding up. We have seen the difference between the members winding up and the creditors winding up. We have also seen what is the procedure for dissolution, and we have also understood what is the procedure for dissolution under the Companies Act 2013. Under what circumstances petitions are filed, who are the persons who are eligible to file a petition in the court for dissolution of a company, that is the registrar or the central government or the shareholders or the creditors or the persons to whom any money is due, the contributories. All these people are eligible to file the petition for winding up. And upon the petition for winding up, what is the procedure has to be adopted as per the regulations of Companies Act 2013 is all what we have dealt in this video lesson. Hope this lesson has been useful to you. Thank you.